Hello, this is Matt on the Moon Lambeau channel. I've read the SEC's initial lawsuit against Ripple in its entirety twice. And the damn thing's pretty long. I can't remember the exact number of pages, whether it's 70, 80, 90 pages. It's up there somewhere. It's pretty damn long. And then there have been a number of occasions over the last year and a half where I've reread various portions as it was relevant to covering developments within the SEC versus Ripple case. And let me tell you something that's not included in any of those damn pages is an analysis of how XRP applies to the Howey test. Now, mind you, this is at the core of the case. When you're talking about the Howey test, it's a four-part test to determine whether or not something is an investment contract, is a security. And there is no application of XRP to the Howey test in the entire legal complaint against Ripple. Now, things get even more gross because, as I've been pointing out since, I guess it was August of last year, the SEC has removed one of the four prongs of the Howey test unilaterally. Gary Gensler, in fact, has even done this. And why has he done this? Because it makes it easier to sue anyone that they want to sue. And now, it's not that they have the actual power to do this, they're just doing it. Now, attorney John Deaton shared a document in a recent thread, which I'm going to be running through with you in this latest Moon Lambeau Hot Jam, and it's from the SEC themselves. As you can see what I have on your screen right now, this is a document from the official SEC website. This document is titled Framework for Investment Contract Analysis of Digital Assets. This is all about the Howey analysis and how it applies to cryptocurrencies effectively. I don't know that matters to anybody. I just found out that this exists today. I haven't read the whole thing, but I'm going to share with you the relevant portion as it pertains to the conversation that I'm having with you in this particular video. And it's astonishing what they're doing, because I'm telling you, in this document, they acknowledge what a common enterprise is and how it applies to Howey, and then they effectively say, yeah, but we're not going to worry about that. I kid you not, I'm going to show you exactly what they're saying. The SEC is a repulsive organization, and I wish that they would cease to exist as an organization. It's completely ridiculous. I mean, you need to completely, from top to bottom, just pretty much gut the whole thing in terms of who is working there and get new staff in, or something to that effect. I don't know. You got to clean house somehow, because what is happening right now is not reasonable. It is not protecting investors, and it can't stay like this. It just can't stay like this. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so this all started within a thread that attorney Jeremy Hogan started just yesterday, who of course runs the very popular YouTube channel Legal Briefs. And he shared a CNBC story, and it was I think it was a video clip actually here, and it was titled "Bitcoin, Ethereum are commodities," says CFTC Chair Rostin Bainum. Now, of course, my thought was probably about the same as yours. If Ethereum is a commodity, well, certainly XRP would be then. But of course, he didn't mention XRP. That isn't particularly surprising, given that he must be well aware that the SEC is claiming that XRP itself is a security, so he's probably trying to not step on any toes, even though he's in a different government agency entirely. And so here's what attorney Jeremy Hogan had to say in sharing that. He wrote, "Certainly then the CFTC would agree that digital assets similar to Ether are likewise commodities." And then he actually tagged the CFTC chair, again, who was Rostin Bainum. And then Jeremy wrote, "Asking for some friends. Bitcoin, Ethereum are commodities," says CFTC Chair Rostin Bainum. I said that wrong. Bainum. There we go. And then Jeremy said, "Not to be coy, I'm asking about XRP," smiley face. "And if your answer is yes, then you are 100% in line with your predecessor." And what's he referencing there? None other than this article. This is what he linked to from Forbes. It's about Chris Giancarlo, predecessor to Rostin Bainum. So this guy did run the CFTC. And here's the headline from Forbes. This was June 17th, 2020, about half a year before the SEC sued Ripple, claiming that XRP is an unregistered security. The title of this piece is "XRP Isn't a Security, Declares Former CFTC Chairman." So he was already out of that position by then, but still, when are we going to see a sitting CFTC chairman speak about XRP specifically? Well, don't hold your breath. It's not going to happen anytime soon, I suspect anyway. But of course, Jeremy Hogan was referencing XRP because clearly XRP is not a security. It's labeled as a commodity fine, currency fine, whatever. As long as it's out of the SEC's grasp, I'm probably going to be okay with it. I need the specifics, but tell me what you're going to categorize it as. Let me know what the legal implications are there. I'm probably going to be fine with that, though. And then an XRP community member named Yasin responded to Hogan and said, XRP Ledger is more decentralized than Ethereum. XRP never had an ICO, while Ethereum did. Just facts. And then Attorney Hogan responded to that and wrote, not that decentralization is a part of the Howey test, but if everyone wants to focus on that, I'm kind of okay with that, right? And so his point is completely accurate. There's no talk whatsoever of decentralization within the Howey test, but that shouldn't surprise you. Cryptocurrencies didn't exist in 1946 when the Supreme Court evaluated this case. So of course there's no term decentralization, but Attorney Hogan's 100% correct. And so my response to that was the following. I wrote to Hogan and I said, that's true. But if a cryptocurrency is sufficiently decentralized, there can be no common enterprise. That is part of Howey. But that's why it's frustrating the SEC has no policy regarding this. And so hopefully it's clear what I'm stating there. Again, one of the 4 prongs of the Howey test is that there must be a common enterprise. And in order for something to pass the Howey test, which means in order for it to be a security, it must satisfy all 4 prongs of the Howey test. Not 1, not 2, not 3, but all 4. Now, there cannot be a common enterprise if what you're claiming as a common enterprise can't control the asset that you're claiming as a security. So in the case of Ripple, if Ripple ceases to exist, the XRP ledger and XRP continues to exist regardless. Nobody can shut it down. You'd have to stop the entire internet for that to happen, frankly. So clearly, there's no way to satisfy the Howey test, which is part of the reason that the SEC, in recognition of this, I think, it's inconvenient that there must be a common enterprise. That's the prong that they're removing. You'll see as I go forward. And so it's just completely frustrating and ridiculous. And so this is where attorney John Deaton jumped in and he responded to me and he wrote the following. Guys, the SEC simply ignores an element of Howey. And then he shared this document, and he did quote in his tweet the relevant portion. I'm just going to run down to this. It's on the last page of this document. Now, I do want to point out, before going further, if you Google what the Howey test is, there's an endless number of websites that explain what it is. Every single one of them, unless you can find a rare exception, all of them will say that it's a 4-part test. For instance, this is one of the first ones that popped up when I searched for it, just to make this point in my video. Investopedia popped up. And here's the article. What is the Howey test? And you get down, scroll down a little bit, and you can see it's a 4-part test. Number 1, an investment of money. Number 2, in a common enterprise. That's key because that's the one they're removing. Number 3, with the expectation of profit. And number 4, to be derived from the efforts of others. So look at this document that attorney Deaton shared. And he said, look at footnote number 10. And here's what the SEC themselves wrote. So they're acknowledging what the law is. Check this out. This is amazing. In order to satisfy the common enterprise aspect of the Howey test, federal courts require that there be either horizontal commonality or vertical commonality. Period. Now, it's not even, I don't even need to get into the talk about what horizontal commonality is or vertical commonality for this particular video. Why? Because even though in that sentence, they literally said it's on your damn screen, that the federal court requires that in order for this aspect, the common enterprise aspect of the Howey test to be satisfied, they say no. They say that, we're not going to do it. Here's the actual words that they wrote. Here, I'll highlight them on your screen right here. Reads as follows. The Commission, on the other hand, does not require vertical or horizontal commonality per se, nor does it view a common enterprise as a distinct element of the term investment contract. So folks, again, in one footnote, they acknowledge that that federal courts require that there be horizontal or vertical commonality. Federal courts require that. And then in that same footnote, They have the audacity to say, yeah, but we, the commission, the SEC, we're not going to do that. No, this common enterprise nonsense. We're not going to do it. We're just not going to do it. That's what they say in one damn footnote. Can you believe that? This is what they're trying to... And so don't think that this is some sort of mistake in the way that they've written it. Do you remember this video from... this is August 3rd, 2021. I've highlighted this on my channel probably 3 times since August 3rd of 2021. Maybe 4. It's 3 or 4 times. And this is Gary Gensler being interviewed at the 2021 Aspen Security Forum. And he said the following, and I quote, and again, mind you, this Howey test, unquestionably, since 1946 has been a 4-part test, including common enterprise. He was describing what the Howey test is, and this is not a slip of the tongue. He unilaterally is deciding here that it's no longer a 4-part test. So here's what he said, and this is a quote. And if you want to check this yourself, just type in the title of the video here that's on your screen and go to the 42-minute and 35-second mark and hit play, and you will hear it from his mouth for yourself. But here's what he said, and I quote, "The Howey test at its core, 3-part test, but the Howey test is, did you give somebody money in anticipation of profits on their efforts?" That's it. He said 3-part test, so he just threw one of out. You should be scratching your head before he even describes what the 3 are. So how convenient is it that he threw out the common enterprise prong? Now, why might he be doing that? Because again, if you don't have to prove that there's a common enterprise, just that somebody is working and that might increase the value of your cryptocurrency, that's a lot easier to get a slam dunk if you're litigating against anyone, right? But do you understand the implications of this? Because if you're saying that a common enterprise is no longer one of the 4 prongs of the Howey test, which they can't legally do, by the way, precedent has been set. They're just doing it anyway. So we'll see if they get away with it. But why is it so important? Well, think about this. If you don't have to prove that there's a common enterprise, then just say that you're a developer right now. You're a brand new developer. You're like, I want to go ahead and build on top of the XRP ledger. Damn it, because that sounds like a good, fun old time. You're going to do it, okay? And do your nerd math numbers to make something awesome happen on top of the XRP ledger. Cool, right? Not so cool, though, because if at any point you're building, which would help to ensure the long-term viability of XRP and the XRP ledger, if you purchase XRP, well, that's fine. You're not breaking any rules if you purchase XRP, okay? But if you are selling XRP and people are counting on you in any capacity to increase the price of their quote-unquote investment in XRP, if they're counting on you in any capacity, even if you're not a common enterprise, because we threw out common enterprise, if you're just a piece of the puzzle, then the SEC can come after you and seek damages. You broke the law. You're not a common enterprise. You're just a little developer building on top of the XRP ledger, but that's what they're saying they can do. That's how serious this is. These people are complete and utter asshats. What an asshattery they're running at the SEC. I cannot stand these people. These are terrible creatures that nature accidentally made. I'm convinced of that. And they prove it day in, day out. They know that this isn't right. They know this isn't fair. They know this isn't helping investors, yet they do it. They know this. They are not stupid. They're just really bad people. They are truly bad people. And so I responded to Attorney Deaton, and I wrote the following. Wow, so this is why the SEC doesn't seem to care about how decentralized a cryptocurrency is. Because even if a cryptocurrency is decentralized like XRP, meaning there is no common enterprise, this fact doesn't matter because they're disregarding this prong of Howey. Incredible. And then I shared the video, which I just mentioned a moment ago, of Gary Gensler saying that it's just a 3-part test now because reasons. And then I wrote, here's Gary Gensler saying Howey is a 3-part test, throwing out the common enterprise prong of Howey. He said this in August last year as SEC chairman. Go to timestamp 4235 to hear him say this about Howey. The common enterprise requirement of Howey makes it harder for the SEC to successfully litigate, so they're just pretending it doesn't exist. They do this despite decades of legal precedent. The SEC doesn't have the power to do this, but they're trying to get away with it. And folks, that is exactly what's happening, and it's completely repulsive. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.